May I please, your lordship?
Yes.
Maybe, Lordship, I'd like to mention item number 5, Lordship. Lordship, matter may be adjourned for a week, Lordship. Learned counsel, Lordship, who is supposed to argue, Lordship, he is not well, Lordship. I have informed the other side, Lordship.
I have no objection, my lord.
Okay. As agreed by learned advocates of both the parties, this is the matter after
For a week, Lordship.
or a week.
Sorry.
After a week.
Deeply.
Wait, please, Lordship. Lordship, with the due consent of the other side, I beg to mention item number 34 to 38 of this supplementary list, Lordship. This matter, my lord, Mr. B. Kaushik is the conducting counsel, my lord. He is, my lord, out of station because of some medical emergency, my lord. My lord, this matter may be taken up after 2 weeks, my lord. I've taken the consent, my lord.
Lordship, and similar part, I was let me complete my part.
No. No piecemeal way. Mr. Fukun, learned counsel. Appearing on behalf of Mr.
B. Kaushik.
B. Kaushik, learned standing counsel for
Thank you,
the
Lordship.
Elementary Education Department. With concern from the other side, press for listing the matter after 2 weeks, as Mr. Kaushik is out of station on account of medical emergency.
Fine.
Where allowed, rest is list the matter after
2 weeks.
2 weeks.
May I please, I beg to mention item number 6, lordship. Kindly adjourn the matter for 2 weeks, lordship. We need some instruction from our client, lordship, but we fail to contact
You are for,
petitioner. Petitioner.
pardon,
Item number 6, petitioner for petitioner, lordship.
petitioner. Miss, your name please?
J. Chetri.
Jay Setri, learned counsel for the petitioner. With you inform the other side?
Yes, sir. Go on.
With concern from the other side, price for listing the matter after
2 weeks, lordship.
2 weeks. Fair allowed.
May I please, your lordship? Your lordship, back to, with the consent of the other side, I beg to mention item number 11, your lordship.
Item number
11.
11.
Your lordship, some personal difficulties, your lordship. Can it be possible for the day, your lordship?
Mr.
I.H. Laskar.
I. S. Laskar, learned counsel for the petitioner with consent from the other side. Press for listing the matter after
1 week or week.
after 1 week. Fair allowed.
Highly lordship.
I a partner content metallurgy. A fiction the twin one not they super not
You go to the senior bench, mention there.
partner metallurgy. Partner metallurgy.
When do you want?
Hydrology.
Friday.
May it please, your Lordship.
Yes.
Lordship, with the consent of the other side, I would beg to mention item number 25 of the daily list, your Lordship.
20.
25, your Lordship. In the orders column, your Lordship.
25. Yes.
Lordship, I am for the petitioners in this matter. Lordship, I seek a short accommodation of 2 weeks, your Lordship.
Okay. Any objection?
No, 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 no.
As agreed by learned advocates of both the parties, this is a list the matter after
2 weeks, your Lordship.
after 2 weeks. Fair allowed.
Much obliged.
If it may please your lordship, I'd like to mention for listing an interlocutory application in the next date if possible, your lordship,
Interlocutory application.
for correction of
connect number.
orders. In regards to correction of orders.
Okay.
9.
Items for admission, item number 1.
Madam, I am paying for this matter will be taken on Friday.
Why Friday?
The copy of the affidavit, madam. Today I am fixing it, madam. I will file it back tomorrow.
Ms. Satya, learned standing counsel for the respondent in elementary education department. Submits that she has not received the affidavit, additional affidavit. And price for listing the matter after
Madam, on Friday.
Friday, fair allowed. Fair allowed, recess shall list the matter on Friday. Miss
Yes, sir.
learned counsel for the petitioner present. None appears for the petitioner on call, lays the matter after 1 week.
Item number 3.
May I please lordship? Okay.
Accountant general.
On the last occasion, my lord, Mr. Pankaj Datta, my lord, was taken time, my lord, for instruction, maybe, my lord. So, Pankaj, not.
Okay, voice for the secondary education department.
Pankaj Datta. Pankaj Datta.
All coordinator. You know, nothing doing. After some time.
Item number 4.
We have to obtain instruction. So we have not obtained instruction. Kindly a short accommodation will be. Lordship. Also instruction done.
Lordship, this may be the last chance, Lordship.
You are for BTC.
It is.
Heard Mr. Dhor, learned counsel for the petitioner, and Mr.
Be forming on behalf of AKB.
P. Bhomik, learned counsel appearing on behalf of Mr.
AKB.
A.K. Bhuya, learned standing counsel for the BTC. Mr. Bhomik submits that he has not received any instruction and press for listing the matter after
2 weeks.
after
te-
2 weeks
10
parallel.
On 10th of February, Lordship.
10th
She is going to retire on July, Lordship.
Okay. 10th of February.
Date,
Item number 7 and 8.
date may be fixed, Lordship.
10th of February.
10th of February. Lordship, of life.
On the last of it, it's in last in government application. Was directed to produce the record and instruction. 11 records. We tried, there was some changes in the administration, that district commissioner has been transferred out. So they are asking for 7 days time.
Is there your name, please?
This is Talukar.
Learned, you are standing counsel?
No.
You are
It's
senior government advocate. Okay. Appearing for the state respondent submits that the matter may be listed after 10 days. After 10 days. Pair allowed. None appears for the petitioner on call. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
My lord, no, item number 2, my lord, I'm sorry, my lord, I couldn't hear.
Take a that from him.
My lord.
Item 9.
May I please, your Lordship? Lordship, this is with regard to non-release of security deposit. And the railways have filed an affidavit. Now, their only contention is, there was, I'll take your Lordship to the affidavit filed by the railway. First of all, your Lordship may come to page para 4 of the affidavit. Here, it is the contention of them that there was an arbitration proceeding going on with regard to that same contract. And so the security deposit should not be released. Then again, they say that the award was passed in my favor, your Lordship. Then they have enclosed the sanction letter by which the entire awarded amount was sanctioned in their, to be released in my favor. The only contention now your lordship will find, they are referring, the arbitral award was passed, if your lordship comes to their annexure,
Hmm.
annexure I at page 47. If your lordship has got it. Here, your lordship will find that the award, arbitral award dated 18/4/21. At page 47, annexure I of their affidavit. Your lordship has got it.
Yes.
Now, in the sanction memorandum, this, on the basis of the arbitral award given in favor of me, this was the sanction given by the railways. The
Hmm.
award, your lordship may kindly note the date. It is 18/4/2021.
Hmm.
Second line, your lordship. Sanction is hereby accorded to the release the amount of arbitration for arbitral award dated 18/4/21, published by such and such, and the amount has been given as 37 such and such. Now, they are now referring to a letter which was issued even prior to the initiation of the arbitration proceeding at annexure Art 3 at page 49. Here they want here your lordship will find in this this is a pre-arbitration thing. This was one of the issues before the tribunal. As such, you are required to submit the PVC bill as per CA condition and an unconditional no claim certificate for early payment. Now, they say in para 5 of their affidavit that because I have not given the no claim, the security deposit and earnest money cannot be released. Whereas they have made the entire payment of the arbitral amount. We have received it also. And para 5, they say, if your lordship comes to page 45, their only stand for not releasing is this, your lordship. With regard to the statement made in such and such, the humble deponent begs to say that the respondents are not adverse to release the security deposit and earnest money, but the request in the proper form has not been. What is the proper form, your lordship? I am before this honorable court for release of the security deposit. An arbitral proceeding was there. They have released the entire amount in my favor. Now they, means after this proceeding was initiated by me before this honorable court, the arbitral award has come into being passed. But their only contention now is that I have to give in a proper format. How and that too an unconditional no claim. How can a person be compelled to give a no claim certificate when it is my dues are there? They admit to that. And even the arbitral award has been given to me. The entire amount, they have not retained anything what was there. They have not assailed the judgment. They have not assailed in under 34. Now they are holding back on the ground that I have to give in a proper format. I am before this honorable court seeking release. They have filed their affidavit. What is the harm in releasing the security deposit? What is the proper format when a person is before this court, have filed this application seeking release and they say they are not adverse? Now, what is the proper format? There is nothing on there. They only want, if I go to a pre-arbitral awards letter that is of
Since when it has not been released?
Yes, your lordship.
Since when?
It was passed, the final bill was given in 18/11/2016.
2016.
Yes, final bill was there. From when the final bill
When
is
they are
given,
supposed to return the amount?
pardon, lordship?
When they are supposed to return the amount?
As per the terms of the contract, your lordship will find, if your lordship comes at page 34, your lordship. Page 5, clause number 5.2, if your lordship comes.
Probably you after the
Maintenance.
maintenance period is over. That period is already over, but it was not returned due to some disputes between the parties.
That is also over.
Petition was pending,
Yes,
and I have
that
been
is-
informed by a senior that the arbitration proceeding is already over. Now, now probably it has to be written, but I do not have the.
You
up-to-date
need some time
instructions.
to look at.
Require some time. Let it be posted in next week, my lord. I'll take the.
There is otherwise nothing on to be this.
Well, because of the pendency of the arbitration proceeding. Now it's over, as told by my CJ.
No, it is your sanction, but.
When the arbitration proceeding was over?
No, তোমালোকৰ affidavit.
When the arbitration.
It was 18/4/21, your lordship.
21.
That is the sanction letter of theirs only. তোমালোকে in their own affidavit, they have annexed that. They have even sanctioned the release of the arbitral award that I pointed to your lordship.
Let me have my instructions, my lordship, posted in next week. I will get my up-to-date instructions.
Heard my services, learned counsel for the petitioner, and Mr. Sharma, learned standing counsel for the respondent authorities. Mr. Sharma submits that he may be granted 1 week time to obtain instruction. Up to date instruction, fair allowed, recess and list the matter in the next week. Should we fix a date?
Yes, it may be disposed of next week. On the next day, it may be disposed of.
Okay. On
Yes, sir.
that day, an endeavor will be made to finally hear and dispose of the matter.
Highly obliged.
Number 10.
May I please your lordship? May I please your lordship?
Yes,
The matter relates to land acquisition and compensation. In last occasion, they have taken time to file affidavit, lordship. Respondent side has taken time to file affidavit.
so you have filed your affidavit.
My lord, we have filed a affidavit in opposition, my lord. But now subsequent development is there, my lord. The petitioner was asked to furnish the original copy of the, my lord, Potta, my lord.
Yes,
Then we found that the Potta, that Potta is a forged one. So we are taking steps to send the, my lord, that original Potta, my lord, to the forensic science laboratory with the signature which were appended in the original Potta with the officials, my lord. So, 3 weeks time may be granted, my lord, to us, for it. Bring it on record, my lord. Resulting in the enquiry, my lord. Road has already been completed, my lord. Further petitioner will get the compensation on the basis of that particular document. And the 3A notification and 3D notification under section, under the National Highway Act, land of the petitioner was not notified. It is the, my lord, but the petitioner claimed on the basis of a document, my lord, subsequently before the competent authority for land acquisition, seeking compensation. Then we found that the petitioner submitted the original Potta. Then we found that that Potta, there is no record in the Jamabandi or Sita, and it is a forged one. So we are taking steps to send it to the forensic laboratory.
But lordship,
Art-
Pata was given by the revenue office only.
So the signature of
Yeah,
the
she has
referee
applied.
in that particular, my lord, I have the enquiry report. And that those persons whose signature was there, they wrote to us that their signature is a forged one. So this document along with the original Potta, we are taking steps to send it to the forensics laboratory.
heard miss,
KLR Yanthan.
a learned counsel for the petitioner, and Mr. Jayaswatia, learned standing counsel for the respondent. Go for the respondent number
429, my lord.
429.
Katiala Kapama. I am doing.
Sir. Soikia. It was Soikia. Okay, for respondent number 3. Respondent number 3. For rest of the respondent, respondent number 1, Union of India. None of this for the, and respondent number 2, National Highway Authority. Okay.
And it's a reset.
None of this for the respondent number 1 and 2. 1 and 2.
Ten. Other number two.
Mr. Jayaswatia, learned standing counsel for the respondent number so and so submits that. Though the respondent number so and so have filed their affidavit in opposition, yet their there is subsequent development and the petitioner has produced one original land patta,
Periodic pattern.
original periodic patta, and the same is found to be false, and step has been taken. Step is being taken for. You have already sent it to the.
We are taking steps to send it to the
Okay,
forensic science.
and steps are being taken to send the same to the FSL for confirmation, and he pressed for 3 weeks time to file additional affidavit. Where allowed, rescission is a matter after 3 weeks.
Number 12.
My lord, may I please your lord?
Hmm.
Here, NHA detail to support file affidavit, I said, maybe in that case, 10 days time. Or
10 days.
10 days or 2 weeks, my lord.
Fix it.
Or-
date here.
Mr. Islam Learned Counsel for the petitioner. Then Mr. Borua for respondent number.
Or anything, it is still going. 2 weeks, 7 million.
Respondent number 2 and 7, you. Respondent number 6, you. Mr. Roy,
3, 4, 5.
3, 4, 5, you. 1. Mr. Borua, Learned Standing Counsel for the respondent number so and so. Praise for granting him 2 weeks time to file counter affidavit.
Right.
Fair allowed, rescission is the matter after 2 weeks.
Paid for listed dates, there's urgency in matter, your worship. Paid for listed dates, yeah, they're difficult to list. That my compensation amount is released to other person. Then compensation matter. Fix a date, your kindly.
120, 0.
28 February.
Item 13.
Please, your lordship. Lordship, time being my senior is busy, another court lordship, please after 2 p.m.
Lordship, I pray for some more time, Lordship, I'm going to file an affidavit. 3 weeks time, I will be.
3 weeks. Heard, Mr.
Eke Kanu yours,
A.K.
Kanu.
Learned Counsel for the petitioner, and Mr. J. Hendik, Learned Standing Counsel for the respondent. Mr. Hendik, you are for respondent number?
I am for Lordship. State government. State council, Lordship.
1, 2, 3, 4.
2 to 4.
2, 2, 4. 2, 2, 4. And you for? 1. Mr. Hendik submits that he may be granted 3 weeks time
Lord,
so as to enable him to file counter affidavit. Where allowed, rescission is the matter after 3 weeks.
Item numbers 14 and 15.
14 and 15, Lordship, affidavit, signing affidavit has been received. Within a week, Lordship, we will file the affidavit.
14, 15.
14 and 15.
Yes, Lordship. Lordship, may I pass over for the timing, Lordship?
No, he has not yet filed the affidavit.
Oh, yes, Lordship.
Heard, miss, your name, please?
Bidas, Lordship. Lordship,
Learned
interim
Counsel for the
continue, Lordship.
petitioner. And Mr. Hendik, Learned Standing Counsel for the respondent number. The state respondent. Mr. Ahmed, you are here?
Yes, that's one of the 8, 7, 8, 8, 9.
7.
3 and 4.
Mr. Hendik for 3 and 4. Mr. Ahmed for respondent number 7 and
8 and 9.
7, 8, and 9. Mr. Hendik prays for granting him how many weeks?
Within a week, Lordship, we can file. Lordship,
Submit
10
that
time,
he may be granted 10 days time to file counter affidavit. Fair allowed, rescission is the matter after 2 weeks.
Interim continue.
Mr. Hendik, 2 weeks or 10 days? 10 days.
First of this. Lordship, interim may continue, Lordship. Interim may continue, Lordship.
Interim.
Interim, yes.
Okay, interim order pass earlier shall continue.
Stop this.
Item number 14.
May I please, the lord? My lord, in this matter, my lord,
petitioners are claiming, my lord, compensation, my lord. In this-
This case, my lord. For last order from because we have already paid, due compensation. Question, but what happened, I think they are not satisfied, there is a provision on the section, in the file of National Highway, the 1953, which is in fee, not present. That is why, that question is to be decided, whether, now my learned friend is, you get to know.
Yes,
Page number? Page key.
yes, my lord. One voted. Page 139, one.
It is. It will be. Yes. Yeah.
Yes.
It's lordship law, because that issue is law point is involved here. Anyway, they want to make the lordship. If lordship pleases, that can be. But under provision of section 385, there is a provision. Of course,
One-
if him can be.
No,
can be done by it.
before the computer order, my lord, page 143 annexure 4 submitted, my lord, detailed representation. my lord.
But once it is in paid without, now, computer role is gone. Release right, after payment, if somebody lost it, you compensation, there is a provision under section 385 below anything. That is why, that's why, this amount for in last, is a state for maintainability. We can. That is why, there is a provision, ADC once it is given, how he can decide his own decree? He cannot be, there is a provision for review. He has to go for arbitrator. Arbitration. Arbitration to decide.
Before the government, no? Then, my lord, I will submit this, my lord, before the government, my lord,
No, before the arbitrator.
arbitrator, my lord.
Before there is an arbitrator. He can very well, because it will be, yeah, what to say.
Now, what is your pay?
My lord, my prayer is that, my lord, I may be allowed to, my lord, if my lord, friend is staying, my lord, then I will approach to before the arbitrator, my lord, with proper representation.
Yes.
You want to withdraw this?
My lord, with this observation, my lord, maybe
With
discuss.
this one also. With that observation, can be. Lordship will be lordship, the changes. That's it. PG. Lordship got it.
Yes.
PG is 5.
Five. Okay.
Section 3G, 3G5.
Yes.
My,
The amount lordship got it determined by the complaint under the under subsection so is not action to the either of the parties. The amount they have to learn it by the arbitrator to be appointed by the central government. Already we listen arbitrators, that official structuring.
my lord, my representation is also under section 3G. Lordship kindly may look 143, my lord. Only they are saying, my lord,
They are saying
addressee-
I wish to go to arbitrator.
yes, my lord, according to them, my lord, it should be addressee should be arbitrator, my lord.
These are not similar.
Page number?
Page 143, my lord. Subject, my lord, an appeal under section 3G of the National Highway Act. No, hope-
After this one again.
Computer order. That may be, my lord, I will file, my lord, before the
Yes,
arbitrator.
the second arbitrage there. It took place.
We can dispose of this petition. We can dispose of this petition.
Definitely, sir. Because see, he himself is approach this arbitrator also. Now this chief will forward this to the arbiter also, there is a provision, and he has mentioned in the above arbiter also.
So you will file a fresh appeal,
But that may be also forwarded, my lord.
this one.
Yes, one. Oh, no, I have no problem, my lord. I may also file, my lord, the fresh one. my lord.
Fresh one.
Fresh one, my lord.
Okay. Will dispose of this, please. We'll pass out.
Oblige, my lord.
Item 17.
With your lordship.
Hmm.
Here is case, my lord, the petitioner is aggrieved, my lord. At the freezing of his bank account, my lord. Like kindly page the last quarter, my lord. The service on the respondents were completed, my lord. But none is, from the call list, it is shown that, my lord, none is represented by the respondent, my lord. State Bank is the main party, my lord, here.
State Bank.
State Bank of India, my lord. They are the parties,
Any
my lord.
standing counsel for the State Bank?
Lord, there is notice were served, my lord. After serving the notice, my lord, they usually engage their panel advocate, my lord.
Okay, State Bank or standing counsel. আগতে এবাৰ কোনোবা এজন এপ্লাই কৰিছিল। আগতে এবাৰ ষ্টেট বেংকৰ কোনোবা এজন এপ্লাই কৰিছিল। এই চেন্স After some time, he will contact the standing council.
My lord.
Item 18.
My lord, in
Mr. Gore, you received the affidavit?
yes, my lord, I have received the copy, but my lord, in the affidavit, my lord, there is nothing about, my lord, acquisition of land, my lord. They have installed a electric pole on my land, my lord, my patta land, my lord. My lord, first the land have to be acquired by the government, my lord. These affidavits are, my lord, regarding the contract work for installation of the pole and like that, my lord. At least, my lord, first they have to, my lord, ask the collector to acquire the land, my lord. Without acquiring, my lord, how they can install, my lord. And my lord, on being came to know about their planning for installing electrical on my land, my lord. I requested, my lord, on 1/12/25 to provide me the notice if any whereby my land has been acquired, my lord. No notice, nothing else, my lord. Because, my lord, unless, my lord, my land is acquired, my lord, because they have to make the payment of compensation to the, my lord, government, my lord. And the government will disperse it to me, my lord. So without,
That's all right. That will be considered at the time of hearing.
my lord,
They have already filed their affidavit.
my lord, they are, my lord, the electrical department, my lord. Electricity department, my lord, APDCL and AIGCL, my lord. They will not make the payment to me, my lord, for compensation, my lord. Because if my land is, my lord, my land is used for their purpose, my lord, then I am entitled to compensation, my lord.
So that's all right, but who filed the affidavit? Respondent number? 5, 6, 7, and 8.
Assam, my lord, they are, my lord.
And you are representing the other three, 1, 2, and 3?
My lord, respondent number two, my lord, that is deputy district commissioner, my lord, they have to clarify the matter, my lord, whether my land has been acquired or not.
Yes, are you interested to file your affidavit? Yes.
Land has been taken by them, lordship.
No, they cannot take without.
But that is why they have to give us requisition that land has to be acquired.
Yes, that is the process, my lord. Without giving the requisition to the, my lord, collector, how they can install the pole, my lord? That is the question, my lord. They have.
You have filed your affidavit.
No.
Would you like to file? When? No, maybe, you file your affidavit, we'll see. Heard Mrs. Jessie Gore, learned counsel for the petitioner. Ms. Fokon, learned standing counsel for the respondent number 5, 6, 7, and 8. Ms. Fokon submits that she has already filed affidavit in opposition. Mister, your name please? And? Goswami, learned counsel for the respondent number 1, 2, 3, and 4. Submits that he may be granted some time to file the affidavit in opposition. Pair allowed, recess list the matter. After 2 weeks, in the meantime, Mr. Goswami shall file his affidavit in opposition. You have not filed your affidavit.
Affidavit has not been filed, but this communication lordship. So, filing postponed this communication. Lordship, this was the matter relating to the old entitlement of the petitioner in the old bank on lordship. He's claiming. So for this issue, lordship, would have taken the legal various department.
No, have you filed your affidavit?
Yes, lordship.
Where?
This report is being prepared by the Director of Secretary Education for onward submission to the Government Secretary Lordship. So after compilation of all the reports and after that, a decision would be taken, Lordship, whether petitioner would covered by that judgment or not.
So now what to do?
Lordship, I need another 4 weeks time, Lordship, for completion of this formalities, Lordship.
My lord, regarding coverage, my lord, already this honorable court has already settled the issue, my lord.
So in respect to other petitioner, whether
What?
the petitioner would come.
Petitioner was also in that case, my
Let them examine the matter then.
my lord,
Huh?
my lord, my lord,
Some informations are being sought
my lord.
for disposing of the pair. Heard Mr.
Shake, my lord.
Learned counsel for the petitioner and Mr. P. Dotto, learned standing counsel for the respondent number,
Secretary Department, Lordship.
respondents in secondary education department. Mr. Dotto has produced one letter dated 13/1/2026 of the Joint Secretary to the Government of Assam addressed to the Director of Secondary Education and Director of Elementary Education, seeking some information. And on receipt of which, and he also submits that on receipt of the said information, the authority will examine whether the present petitioners are similarly situated with the petitioner in WPC number 7318 of 2023 or not. And he press for listing the matter after 4 weeks. Pair allowed, recusal is the matter after 4 weeks. The letter produced before the court today shall be marked as annexure.
May I please for fixed date, my lord, after 4 weeks?
Annexure N,
Lordship.
and we take to the record. List the matter after 6
Hello.
of March.
Highly obliged.
Respect my understanding. Sorry, when the matter 9, sorry, my lord, when the matter 10 called for, I am on late in court number 6, my lord. My presence may kindly be recorded for responding 1 and 2, lordship, and I have already filed my affidavit. Union of India and the NFIDCL, my lord. Item number 10, my lord.
Okay,
Lordship, my, deeply obliged. It will be.
Well, so they are supposed to file affidavit.
It's received, my lord, has already, I'll file by tomorrow, my lord. Even today I'll file, but by tomorrow it will.
item number
39.
39 and 41,
Forty.
both are similar.
The affidavit, but 49 I have received the affidavit.
Let them file the affidavit, Lord.
heard Mr. Decker, learned counsel for the petitioner, and Miss, your name please?
My lord,
Your name?
you does additional senior government advocate.
You does additional senior government advocate for the respondent in,
All responded.
or all the respondents. Miss does submits that she may be granted 1 week time.
But typically by tomorrow, your option may not to 1 week time. But
Grant 1 week time so as to enable her to file the counter affidavit. Pair allowed, recusal is the matter after 1 week. After 1 week.
41, I need more time.
Yes, 41 is similar.
Fixed time may be granted.
Heard Mr. Decker, learned counsel for the petitioner, and Ms. Das, learned additional senior government advocate, and she submits that she has not she may be granted 4 weeks time.
Well,
4 weeks time to file affidavit in opposition. Pair allowed, recusal is the matter after 4 weeks.
So after 4 weeks, that may be fixed, Lords.
Okay.
Otherwise, no. Yes.
6 March.
And so far 39 is concerned, that means 6 months. Oblige, Lords. Did you?
40.
38, say. 42,
May please, your lordship.
2 weeks time to file our affidavit.
You are
For corporation department. Corporation department. Number 1, 2, 3, and 4, 5.
Earlier also they had taken time, my lord. The only thing, my lord, this is a case of deemed approval, man. Well, we had notified in time. We had held the meeting, annual general meeting for election, my lord, in time. We had submitted the proceedings thereof in time. And the duty on the respondent was to approve or reject the proceedings within a period of 15 days, which they didn't do. We submitted it on 10/10/25. So they had time till 25/10/25. 15 days, man. And they passed order on 4/11, man. Clearly, my lord, they have violated this section, man. Section 45, man. I don't know, my lord, what.
Mr. Goswami, let them file
affidavit
their
will-
affidavit.
Final, 2 weeks. Already there is an interim not to take steps regarding election.
Heard Mr. Goswami, learned counsel for the petitioner. And also heard Mr.
K. Sotyal on behalf of SK Talukdar.
Learned counsel appearing on behalf of Mr. S.K. Talukdar, learned standing counsel for the co-person department. For the respondent number 1 to 5.
1, 2, 3, 4, and 5.
1, 2. The learned counsel
Respondent 6 was deemed to be submitted.
for the respondent number 1 to 5. Praise for granting 2 weeks time to file counter affidavit. Pair allowed. And that has already been observed in respect of respondent number 6.
6.
List the matter after 2 weeks.
Well, may I pray for a date?
COVID.
My lord, and then interim order to continue.
Interim order pass earlier shall continue.
Much obliged.
Kindly
peruse the last order.
And then it is not next minute.
Pardon?
And then to me, it's not next minute after something.
After some time. Oh.
In this proposal of the petitioner was split the finance department.
Whether finance department is a party here? No. Anybody from finance department? No. Can you inform Mr. Soliha after some time?
Lordship was thinking of like the another one. Lordship may kindly take up this matter after some time.
After?
After some time, Lordship.
My lord, may I please your lordship, my lord, I am for the petitioner, my lord. Learned senior counsel K. N. Chaudhary is out of station, my lord.
Pardon?
K. N. Chaudhary sir is out of station, my lord.
Hmm.
So, my lord, that the matter has to be heard in his presence, my lord.
Okay. Mr. Your name, please?
My lord, A. Ali, my lord.
A. Ali.
My
Heard Mr. A. Ali, learned counsel for the petitioner. Then also heard Mr. Das for respondent number?
6.
6. And you?
On behalf of Mr.
On behalf of?
Mr. H.K. Das, Lordship. Number 5.
Learned counsel for the respondent number 5. Mr. Ali submits that conducting counsel Mr. Ken Soruri is out of station and he pays for listing the matter after
Next week on any day.
next week. After 1 week, parallel, recess and list the matter after 1 week.
Obliged. Obliged.
May it please your lordship. Lordship, this writ petition was filed for the noise pollution created by respondent number 9. For the noise pollutions created by respondent number 9. Lordship, Pollution Control Board has already filed their affidavit, Lordship. And service is also complete, Lordship. So it may be disposed of, Lordship.
So service completed here?
Yes, Lordship. As per order dated 18/12/25, service is deemed deemed
Upon
complete. on
respondent number 8. And for rest of the respondent?
Pardon, Lordship.
Rest of the respondent?
Uh,
All the above? For respondent number? 9.
And others are all official respondents, Lordship. Others are official respondents, Lordship.
Eighteen 12. Yes. Heard, Mr.
She Sharma, Lordship.
Learned counsel for the petitioner. And also heard Mr. Learned counsel for the respondent number 9. You for 5, 6, and 7. Order of the Lausian Court dated 18/12/2025 indicates that service upon respondent number 8 has already been completed. But none appears for the but the respondent number 8 remain unrepresented today. So service completed in respect of all the respondents. Recessal list the matter for admission hearing on 2017 matter on 24th February.
Obliged, Lordship.
Mr. Borbozari, one matter has been forwarded to the finance department. Can you obtain up-to-date instruction? File number 295395 of 7 dated 7/1/2026. Heard Mr. Islam, learned counsel for the petitioner, and Ms. Sutia, learned standing counsel for the contender. Ms. Sutia has produced one letter of the Deputy Secretary to the Government of Assam Department of School Education dated 7/1/2026. And on the basis of the said letter, she submits that the proposal has been sent to the Finance Department by file number 295395 of dated 7/1/2026, seeking their concurrence. Mr. Borbozari, learned standing counsel for the Finance Department, who is present before this court, is requested to obtain up-to-date instruction in respect of the file number so and so, and to apprise this court on Friday. Recessal list the matter on Friday. The letter produced before the court today shall be marked as Annexer Y and be tagged with the record.
Obliged.
Item 23. 23.
None appears for the petitioner on call. However, you are for?
For the respondent number 3.
Mr.
Find
Purple.
our affidavit. Perhaps my lord, the matter has become infactual. Matter pertains to my lord, the service benefits of erstwhile my lord employees of Hotel Brahmaputra also. With the suggestion to our High Court building. Now that Hotel Brahmaputra also has been dismantled long ago and a new building has come up. So at that point of time, my lord, there was a severance package, my lord, executed between the employer and the employees, my lord. But being dissatisfied with those, my lord, benefits given to the erstwhile employees, this petition has been filed. The much water has flown in between, my lord. My respectful submission, my lord, that matter has become infactual. Nonetheless, my lord, since petition is central, can consider.
None appears for the petitioner on call.
Otherwise,
However, Mr. Borbozari,
Bench matter.
You are for the respondent number,
Respondent number 3, my lord.
respondent number 3,
The managing director of Assam Tourism Development Corporation.
respondent number 3, the managing director, Assam Tourism Development Corporation Limited, present. None appears for the rest of the respondent. Mr. Borposer submits that perhaps this matter become infructuous. But since the petitioner remain absent, petitioners remain unrepresented today, rest shall list the matter after 1 week. After 1 week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow.
And so, 24.
May please your lordship. Lordship permitted us to take a step upon respondent number 7 through trustee mood lordship.
Respondent number 7.
Lordship, accordingly, petitioner offered notice to the respondent number 7 lordship, but respondent number 7 refused to accept the same. We have filed affidavit to that effect, lordship.
Hard miss,
F in touch, lordship.
learned counsel for the petitioner. None appears for the respondent. You are for respondent number 1. Respondent number 1. The learned counsel for the petitioner submits that the petitioner was allowed to effect service of notice upon respondent number 7 by Dusty Mood. And though an effort was made to effect service of notice by Dusty Mood, the respondent number 7 refused to accept the same. And to that effect, one affidavit will be filed and she prays for granting 1 week time.
Lordship,
1 week time to file the affidavit.
we have already filed, lordship. Kindly peruse flag A, lordship.
When did you file?
22/1/26, lordship.
And to that effect, one affidavit has already been filed on 22nd of January 2026. It appears that the notice upon respondent number 7 deemed to have been served, but the respondent number 7 failed to remain unrepresented today. Rest shall list the matter after 1 week. In respect of rest of the respondent service completed,
Complete, lordship.
rest shall list the matter after 1 week for admission hearing as service in respect of rest of the respondents stands completed.
Kindly date may be fixed, lordship.
Okay.
On 13 February.
Of less.
Paragraph 26.
Wait, please, your lordship. Lordship, the service has been completed upon all the respondents.
Heard, Mr.
I take a lot.
Learned counsel for the petitioner. And also heard
I'm appearing for respondent by 8, lord.
R. Debbie, learned counsel for the respondent number 1 and 8. 1 and 8. Ms. Bora for respondent number 6. Anybody? And Sharma for respondent number 2 and 3. 2 and 3. The learned counsel for the petitioner submits that service upon all the respondents stands completed and the matter may be listed for admission hearing. Accordingly, it is provided that rest shall list the matter for admission hearing after 1 week.
Lordship, there is one more prayer. Lordship, the name of D. Gogo is wrongly entered for the petitioner. That may be struck off.
The learned counsel for the petitioner further submits that the name of Mr. D. Gogoi
Yes, Lordship.
is wrongly reflected against,
For the petitioner.
wrongly reflected as the counsel for the petitioner, and his name may be deleted. Accordingly, taking note of the submission of learned counsel for both the parties, the rest is directed to do the needful in this regard.
What's up?
Paragraph 27.
May I please, Lordship?
Lordship, here, Lordship, I request some time for filing my affidavit, Lordship.
Lordship, service upon respondent number 6 also completed, so far office net 8, my lord, 1/2026 concern. So, my lord, let them allow to file affidavit in for the admission hearing, fixed for admission. No.
Heard Mr. K. Bhuiya, learned counsel for
I'm
the
for-
petitioner.
Respondent number 7, respondent number 7.
Already
Okay.
filed, kara tumar.
Mr. Roy for respondent number
3, 4, and 5.
3, 4, and 5. And Madam 6, 1. And you for 7.
I'm for 7.
Okay. Mr. Bhuiya submits that service upon all the respondents is then completed and the matter may be listed for admission hearing. However, Mr. Roy learned standing counsel for the respondent number so and so. Price for granting him
4 weeks, sir. 4 weeks, Lordship.
4 weeks time
It is, my lord, 2024
to file the counter affidavit.
case.
Pair allowed.
My lord, date may be fixed, my lord.
Registry may list the matter. Registry shall list the matter on 10th of March.
Highly obliged.
In the meantime, rest of the respondent may also file their counter affidavit.
Obliged, Lordship.
Well, can it be on 11 March, madam? 10 March, 12, on 11 March. 12 March. I don't really.
Well, in this case, my lord, this contempt case, my lord, from the government side, last occasion, my lord, observed that it will be considered by the higher authority. That's why we serve one notice and this letter has been issued. Caste certificate has not given to us, my lord, because already verified. Authenticity has to verify it and thereafter issue the caste certificate. But last occasion, my learned friend said, my lord, submitted, my lord, that the higher authority will provide. But this letter has been issued to me. Deputy Commissioner is the absolute authority, already verified. All papers have been verified.
Now, what is your submission?
My submission is that my lord, Deputy Commissioner verify my all papers, my lord, what has been already verified also.
So deputy commissioner is not a party here.
He is the absolute party, my lord. He is the sole party, my lord, contempt not.
Oh,
But this higher officer, my lord, was not implicated as a party respondent. That is why with a view to implicate him as a party respondent in the contempt case, as per suggestion from the other side, we have served this notice, but they have prepared in this way. This letter?
Yes.
Letter has been already placed possibly, my lord, my learned friend.
My lord, they have already placed the instruction dated 24/7/2025
Hmm.
on the last occasion. Senior had placed the instructions.
Hmm. Mr. Das, you said direction was to file requisite application in prescribed form in terms of the office memorandum dated 8/8/2022.
Obviously.
And So in terms of office memorandum dated 8/8/2022, who is the appropriate authority?
DCF is Deputy Commissioner, my lord.
Deputy Commissioner.
Deputy Commissioner.
So Deputy Commissioner is not a party in this proceeding.
The Devakima Mr. is here, my lord.
Where?
First, contemporary number 1. District
Having
Commissioner.
And you are appearing for respondent number?
So respondent. Respondent number 1.
So you have not disposed of his application till
Yes,
today.
yes.
My
Yes.
lord, I seek for some time to get the instructions regarding the pendency of the applications and to get further instructions regarding what is the process that is taking place in this particular matter. We had placed these instructions on the last occasion. According to this, the application had to be submitted according to a particular office memorandum.
Already verified, last order reflects.
So my lord, I pray for some time to get instructions on this matter.
Heard Mr. H. Das, learned counsel for the petitioner, and Mr.
G. Anthony on behalf of D. Nath.
Learned counsel appearing on behalf of Mr.
D. Nath.
Learned counsel for the contender number 1. The learned counsel appearing on behalf of Mr. D. Nath. Learned counsel for the contender press for granting some time to obtain up-to-date instruction. Pair allowed. Recessal is the matter on Friday.
In this case, literally I appear for the State Bank of India. As independent counsel. Now I have done for the record below. Notices have been served upon the below branch manager, Mongoldo branch. Despite below we have not been informed. Now, 1 week time maybe.
1 week
allowed,
time.
my lord, so that we can.
Heard Mr. Ashok, learned counsel for the petitioner. And also heard Mr. B.K. Sen, learned panel advocate. Panel advocate for the respondent. State Bank of India. Mr. Sen submits that he may be granted 1 week time to obtain up-to-date instruction. Pair allowed. Recessal is the matter on Friday or
Monday.
Monday. Okay. Recessal reflect the name of Mr. Sen in the cause list.
29.
May I please, Your Lordship? Lordship, as per office note dated 28/1/2026, neither EDICAT or neither notice answer has been received. So another date.
Another date. You want to take fresh step?
No, Lordship, one date maybe I.
Okay. Heard Mr.
S.I. Akan.
Learned counsel for the petitioner. Office note dated 28/1/2026 indicates that neither ID card nor answer notice returned in respect of respondent number 1 and 2. Recessal is the matter after 2 weeks awaiting service report upon respondent number 1 and 2.
So obliged.
30.
May I please, Your Lordship? Your Lordship, I require 1 week time to file my reply against the opposition filed by the respondent number 3, Your Lordship.
Heard Mr. Sodiel.
Yes, Your Lordship.
Learned counsel for the petitioner. Mr. Jay Hendik for respondent number
TN4.
TN4. Madam Sharma for 1, 2, and 5. The learned counsel for the petitioner submits that he may be granted
1 week.
1 week time to file a reply to the affidavit in opposition filed by the respondent number 3. Respondent number 3. You have filed your affidavit here.
Lordship, I find.
Okay. Pair allowed recess unless the matter after 1 week.
Deeply obliged.
Item 31.
May it please your lordship, the petitioner's bank account is freeze, your lordship, since May 2024. Lordship, the matter is wrongly listed for orders, your lordship. It should have come for admission. They have filed their affidavit, your lordship, the bank, but the affidavit is not supported by any record, your lordship.
Okay.
We will file our reply.
You have filed your reply.
No, your lordship, we will file our reply. A date may be fixed, your lordship.
Heard Ms. F. Hussain, learned counsel for the petitioner, and Mr.
And Borwa.
N.
Borwa.
Borwa, learned counsel for the respondent number
2 and 3.
Respondent number 2 and 3. And Mr. Hendik for 1. The learned counsel for the petitioner submits that respondent number 3 has filed affidavit in opposition and she may be granted
Lordship, 2 days time, your lordship.
2 days time to file reply to the affidavit in opposition filed by the respondent number 3. Pair allowed recessal is the matter on Friday.
Lordship. Deeply obliged.
May come up for admission.
Yes, lordship.
Yes, recessal is the matter for admission.
Deeply obliged, your lordship.
Item 42.
My lord, as per office note dated 31/2026, my lord, the respondent number 5, that is the private response, she has also received the notice, my lord. Please complete, my lord.
Heard Ms. Anas Thakuria, learned counsel for the petitioner. Office note dated 38/1/2026 indicates that postal tracking report indicates that notice issued to the respondent number 5 stands delivered. And the said postal tracking report is annexed with the record at flag TC. Okay. Second file. Number file TC. Like perusal of the flag. No, perusal of the postal tracking report at flag TC indicates that the item has been delivered. In view of above, notice deemed to have been served upon respondent number 5. But the respondent number 5 remain unrepresented today. In respect of rest of the respondent service completed,
Yes, already served, madam.
the learned
Already.
counsel for the petitioner submits that service in respect of remaining respondents stands completed, and as such, the matter may be listed for admission hearing.
My lord,
SSL list the matter for admission hearing after a week.
my lord, kindly date may be fixed, no?
Okay.
13, no? Obliged.
Lord, as per office note dated 21 January, my lord, notice issued to the private respondents on 28th of January, my lord. Service report with.
There is a official on 31. The 31. The 34, phone number 7 to 8 is not complete. The document that's into the book is not interested.
So postal tracking report indicates that the item has been delivered.
Then the complete number. But it's for marking is the photos. Whether they have received it or not, that is not there.
Okay. Easy. Easy. So as per this report, it was delivered to Guwahati University head office.
The petition, the private respondents are not that University has reached.
So in that case, SSL put up one up-to-date tracking report on
Yes,
next
sir.
date. Heard, Mr.
M. Soikia, my lord.
M. Soikia, learned counsel for the petitioner, and Mr. Bora for the respondent number. Respondent number 1 and 2. Mr. Hendrik, you are here?
3, 5, and 6.
3, 5, and 6. And Miss Bordolo for respondent number 4. Respondent number 4. Office note dated 30th-1/2026 indicates that postal tracking report shows that in respect of respondent number 7 to 10, the notice in item delivered within bracket Guwahati University Head Office white at flag TC. Perusal of the TC indicates that the item was delivered to the Guwahati University Head Office. The office note is not clear whether the item was delivered to the person concerned or not. No, to the respondent concerned or not. In that way of the matter, REST is directed to put up an up-to-date office note in respect of delivery of the item to the respondent number 7 to 10 on next date. List the matter after 1 week.
Yes, please.
After one.
Picture that, my lord.
Covid.
16 in February.
Oblige, your lordship.
Standing under 19.
Please 16 on week, my lord, in code number 27. On personal reference.
Second half. So what to do?
Madam, the password for the day, my lord.
Okay. Any objection?
My lord, I have to take instruction from Mr. R. Islam because he is engaged counsel, my lord. Time to learn, no? Muru no, no?
So if the council is in late, then what to do?
He is also.
Another content matter, my lord, personal reference is going to this one.
Pardon?
Number 23, my lord, personal reference matter is going to.
Oh, common, yes, sir.
This one is.
No, no, yes, sir, to photo.
Okay, let it be tomorrow then.
But
Tomorrow.
madam, tomorrow,
Or miss your name, please.
M. Kurmi on behalf of R. Islam.
Learned counsel appearing on behalf of Mr. R. Islam, learned conducting counsel for the petitioner. And Ms. Sotia, learned counsel appearing on behalf of Mr. N.J. Khatoni are learned. Counsel for the contender submits that Mr. Khatoni is on legs. And she submits that the matter may be adjourned for the day. Fair allowed, rest is the matter tomorrow.
Yes, ma'am.
Tomorrow.
Wednesday, my lord.
Wednesday. Okay, Wednesday then.
Yes, ma'am.
Yes, next matter.
Matters for hearing.
Yes.
Yeah, Lordship, this matter has already been mostly dealt with. Senior counsel Z Kumar was supposed to make the legal arguments, further legal arguments. We have prepared a list of cases. Senior counsel is just on the way, he's on the left, he'll be here just any second. And the report was already submitted by the learned PP. Unfortunately, he's not here.
Who will appear? Respond. Kitten?
It was Mr. P. Borthakur.
Okay. You ready for argue the matter?
Yes, my lord, actually, basically, we all have argued on the merits of the case. Your lordship has taken note in detail. We would just like to sum up the conclusion of the argument and certain legal proposition, my lord, which I will place it before your lordship. That is the only thing to be now looking into.
Yes.
Actually, everything is stated. So for my lord, Puntu dice, my criminal revision petition 100. Your lordship is taking up criminal petition, my lord.
Yes,
Criminal petition number 74, my lord.
yes, 74.
Well, yes, in that case, my lord, I'm the accused person of the case and FIR was lodged by certain people, my lord. And FIR was filed by 4 persons, namely IP Bodole, Rintu Goswami, Kashmira Kostov Borthakur and Gautam Bora against the accused petitioner, which was registered as 468 and 471 IPC case, my lord. So on the basis of that, my lord, they have investigated and submitted the charge sheet against me, my lord. Then it was said by me when I was given that notice, my lord, that the legal notice to the principal JB College, who replied that as per result sheet, Rana Goswami bearing roll number 858 was declared pass. So Guwahati in Dibrugarh University had said not failed, my lord. I have given that mark sheet. Your lordship has already looked into, but still I'd like to place it, my lord. One or two.
Page 53.
Page 53. 53 is the latest.
Page number 50?
Yes. 53 is the later, my lord. I'm trying to show your lordship the mark sheet which the university has given. Yes, my lord. At page 25 it starts, my lord.
Yes.
25 and 26 annexure 3, my lord. In 26, if your lordship will see that in group B English, I have secured 16 out of 25. There I was shown as failed, my lord. But RTI reply on the basis of which the case has been filed, my lord. Then I wrote a letter to the authority concerned, that is at page 53, annexure 9. In response to your legal notice nil dated 7/4/2016, I am furnishing the following points for your clarification. The result of BCom examination held in 1980 was declared in 18-1, and as per result sheet, Rana Goswami bearing roll number 858, my lord, same roll number, my lord, if your lordship will see in the other one also, 858 was declared pass. The university provided furnished mark sheet to the college in respect of each student candidate appeared in that examination, and the college authority delivered the same to the candidate. Further, the college authority issued provisional pass certificate to the candidate on perusal of the mark sheet and result sheet provided by the university. So as it was given to us, we have stated that we have passed the exam. Other records of that period are not available in the college except the result sheet issued by the university. The no two different mark sheet were issued to Goswami by this college, so far my knowledge is concerned. So this is the reply given. So according to this certificate, we have passed the exam, my lord. So in the meantime, my lord, I also filed a title suit, my lord. That is at page 35, my lord. Annexure 7. And in that
Page number?
Page number 35, my lord, Annexure 7. I'm not reading the whole thing, my lord, but the prayer I'm trying to, from there your lordship will get it, on what basis I have filed the title suit. That is degree for declaration that the result of the plaintiff as per result sheet dated 11/9/1981 issued by the examiner under the signature of the dependent number 3 to the different colleges under Dibrugarh University, including pro forma dependent number 4, that is Jagannath Bora College, Jorhat, and the plaintiff mark sheet under the signature of the said dependent number 3 sent to the said college, and that the result of the plaintiff as disclosed in the said result sheet and also in the mark sheet are correct, and that the plaintiff has passed his BCom examination held in 81, and that the BCom degree he holds is a valid one. Decree of declaration that the informant submitted by the office of the defendant number 2 by letter number such dated Iman in response of RTI application by the applicant Pradip Jyoti Datta of Digambar Road, Jorhat, based on table sheet was wrong. Permanent injunction against defendant number 1, 2, and 3
to correct their tabulation sheet and to issue a regular BCom pass certificate to the plaintiff. So on the basis of this, my lord, the case is still pending. They have appeared defendant and they have filed their probably written statement. And and during the course of the investigation, the IO seized the pass certificate of my degree, my lord.
Now,
It is
you
the
tell
same-
me one thing, what is the difference between page number 25 and 26?
My lord, 25 is probably, they have given it, that is my mark sheet, my lord.
Who had given you?
This was seized from me, my lord.
No, who had given this mark sheet to you?
My lord, definitely from the college, I believe, my lord.
College.
Yes, my lord. This is from 24,
And
25.
page number 26,
My
from
lord,
where you got
all
it?
these things were found from my possession. Your lordship will see at page 22, the Caesar list. Type version is at page 21, my lord. Annexure 2, the Caesar list. I say to Lumoni Dwara of Jorhat Police Station do hereby seize the below noted certificate document on being produced by Rana Goswami, son of such of Rajabari Jorhat in connection with the above referred case. The seizure has been made in presence of witnesses seized below. Date and time of seizure is 16/11/16. Place of seizure residence of Rana Goswami, Rajabari Jorhat. Description of the seized article. Certified copy of the BCom final exam mark sheet in the year 81 under Dibrugarh University. Certified copy of the Dibrugarh University admit card number 858. Certified copy of the pass certificate issued by JB College.
No, Mr. Kamar, you see this page number 25 and 26 are not seized document.
No, these are RTI. That is the thing, my lord. 25 and 26.
This page
are
number
all RTI.
25, who had issued this?
My lord, the RTI from the Dibrugarh University, my lord.
25?
Yes, my lord. 25 and 26 are RTI.
Okay.
26 is the RTI.
25 too. I'm checking my certificate of pass certificate. This one pass certificate.
They come from our.
After ask to, then it will be here. So where it is here? Well, it looks like 25 is from us, my lord. If we tally with the Caesar list, NHR 2, my lord. I'll take one by one to your lordship, my lord. Certified copy of BCom final examination mark sheet in the year 81. Actually, it should have come first, my lord. So it is 25. Page 25. Right, my lord? Then we come certified card, admit card, my lord. Admit card is at 23, my lord. My roll number is the same roll number, my lord. That is, I am a bona fide student. I have appeared and cleared all my papers. Then comes the certified copy of the pass certificate. Then this is the pass certificate issued by JB College. My
Which one?
The 24, my lord.
Yes.
3 documents has been seized. These are the 3 documents, my lord.
So 25 is mark sheet seized from you.
Yeah, my lord. Yes.
And 26 is?
RTI, which the informant has done it.
Okay.
And on the basis of this RTI in English, I have failed, so I cannot pass it, is their case. So I have manufactured all this false document, which is not correct. On the face of the record, my lord, that a certificate was given to me that I have passed by the college from where I have appeared, my lord. And if it is an undisputed and of sterling quality, my lord, it should be looked into it, my lord. During the charge sheet, my lord, they have only relied upon that document, my lord. Just because I failed in the English language, my lord. So according to the contention of the informant, that I have lied to the people of the constituency, my lord, regarding their qualification.
Okay. Yes, Mr. Bortakur,
Yes, sir.
what is your stand on this page number 25?
Well, regarding that page number, that is the main controversy, page 25. That is the allegation that that mark sheet was forged. And one mark sheet that is provided by the present petitioner, and another, my lord, other statement, all those, my lord, I have clarified the, my lord, record. That is the, my lord, obtained by way of mark sheet from the Dibrugarh University. Regarding the statement of the controller of the Dibrugarh University, and my lord, everything is there in the record. In that title, so also my the officials of the Dibrugarh University has submitted their written statement. So now, my lord, the only controversy regarding that mark sheet. On the one hand, my lord, JB College has, my lord, issued an certificate regarding the petitioner has passed the become examination. And now, my lord, although that provisional certificate has been issued by the JB College, later on, my lord, he has not, my lord, applied for any original certificate from the university. That is because the provisional certificate. Although JB College, my lord, has issued later on, but that is, my lord, in fact, contradictory, my lord, along with other documents which the petitioner obtained from the, my lord, RTI, by way of RTI or so. My lord, these are the main allegations my lord, from the crux of the matter is that regarding otherwise, my lord, IO's statement, status report, everything I have track mark. He has also found, my lord, lot of, my lord, contradiction between the in both the mark sheets, my lord. One, my lord, supplied by the my lord, petitioner, and other which he obtained from the Dibrugarh University on the basis of tabulation sheet marks. So I only saw on the basis of all these, my lord, records, whatever, only on the I'm submitting on the basis of the record, my lord, whatever is available. So, my lord, only, my lord, because now whether which document is, my lord, whether regarding whether a particular document is false, my lord, fabricated, all those things can only be, my lord, determined by way of, my lord, evidence only. My lord.
Okay, okay. Yes, Mr. Kamal.
Just concluding it, my lord. But the said documents, my lord, has been given the IO. There is no handwriting expert's opinion or any FSL opinion attached with the charge sheet, my lord, that this is genuine and this is manufactured. There is no opinion as such. If your lordship will kindly look into the charge sheet. Yes,
27.
Page 27, my lord. These are 1 to 9 witnesses, my lord. So 4 are the informant of this case up till 4. Then these are other persons as witnesses of figure and all. And if your lordship will see, 8 and 9 are the police officials, my lord. So there is no any averment also. If your lordship wants to, I read. The brief description of the case is there on 2/4/2016. The informant Ishwar Prasanna and all this person, others lodged and written FIR before the Jorhat Sadar police station and informed that on 17/3/2000 on a conference, that is press conference at the Jorhat Press Club, Rana Goswami, the candidate of INC for Jorhat Assembly seat, said that he had passed BCom examination in the year 81 from Dibrugarh University, bearing roll number 858, and he claimed that he completed his BCom from JB Law College under Dibrugarh. The informant on query found that the mark sheet of Rana Goswami bearing registration number such, roll number such, 425 in English, and the mark sheet showed failed against the said roll number. Say Rana Goswami has lied to the people of his constituency that he has passed BCom by manipulating his mark sheet. So that manipulation which the IO himself is saying is not coming from any other sources, my lord. No expert opinion has been sought for. Hence, the FIR lodged against Rana Goswami for causing fraud under 468, 471, and an investigation was started. During the investigation, statement of witnesses were recorded. The mark sheet, admit copy of pass certificate, and from the mark sheet obtained from the Dibrugarh University, the case against Rana Goswami, son of late Nilakanta Goswami, Dibrugarh, is well established under 468, 471, and hence this charge sheet is filed against the accused Rana Goswami. Copy of seizure list, mark sheet obtained from the Dibrugarh are enclosed with a notice of 41A and a checklist is enclosed. The witnesses in column number 6 will prove the truth of the case. This much so much. And the original is page 31.
So now, my lord, this is one aspect of the matter. Now, second aspect is that civil suit is pending, my lord. So till the outcome, my lord, it will determine actually whether my declaratory suit will fail or will pass through the test, my lord. Now, the important point is the other case, my lord. I have also filed a counter case in the meantime, my lord. And in that case, my lord, the police has given a final report. 59 is the order. The impugned order is at page 59, annexure 9, my lord, last page. So I have come up that this order should be set aside and further investigation may be directed. So the investigation proceeds on the right direction, my lord. They should ought to have visited the JB Law College and confront the principal and other staff as to how they have issued this certificate. Shall I read, my lord? Page 59. Page 59, annexure 9. Dated 17/2/2018, learned counsel for the petitioner informant is present by filing Hazira. Today is fixed for necessary order on the objection of the informant of acceptance of the final report. I have meticulously perused the objection of the informant and also the case diary of the document of this case. Case is registered under 120B, 171C, 197, 469, 499, 34 IPC, and the allegation against the accused person are that they have forged the document showing that he never passed the BCom examination from Dibrugarh University. It is further alleged that the informant that his reputation has been harmed by the accused in front of the people, ruining his political career. The IO investigates this case accordingly, and it appears from the case diary that the IO examined the informant and 2 other witnesses of Dibrugarh University. Was issued to him the tabulation certificate or mark sheet of BCom of the informant. It is found in the case diary that the IO, after matching the tabulation certificate with the original mark sheet of the informant, found discrepancy in the number marks and also found that the informant had even never applied for provisional certificate from the Dibrugarh University as he did not pass BCom examination. So provisional certificates are issued by the colleges, not by the universities, my lord. Because that's the JB Law College document, my lord. On the other hand, it also appeared from the case diary that the accused had collected the information against the informant through RTI Act of Dibrugarh, and there is no chance of manipulative of the document against the informant. That these things, the judge himself, with all respect, the magistrate himself is opining, my lord. I have therefore found that the investigation to be proper and is of the view that investigation does not require interference. Accordingly, I accept the FIR so filed by the IO against the accused person, case since disposal. So my respectful submission in this case is that, my lord, the 3 persons were examined and they are the persons from Dibrugarh University. But my documents, which are already seized by the same police, my lord, of the same police station, my lord, and originals are with them, they never examine anyone from the JB Law College to ascertain the fact as to how come this has been manufactured. If he is wrong, my lord,
Mr.
then
Kamar, you
yeah.
see, exam is conducted by the Guwahati University, no, sorry, Dibrugarh
Dibrugarh.
University. So, are they not the right person to say whether the
Yes,
person
at
concerned
the-
has passed or failed?
One way that is correct, my lord, but the other way, there is already another certificate existing. So something is wrong somewhere. That is to be determined first also. Did I manufacture it, or did the college authority issued it, or did the college authority not issued it? That would have been the base purpose. In the other hand, my lord, in the WS filed by them, they have stated that there were some anomalies in recording their things, my lord, which we don't know right now, because that will be decided in the title suit. So my respectful condition, had they examined the JB College persons, my lord, who have issued this certificate under what authority, things would have been crystal clear. Now that part of the investigation was totally not done. This is the IO's opinion, and if I have not manufactured it, they are not saying that these are false, I have prepared it. That means it is genuine documents. The IO never said that these are falsely prepared documents, these and that.
There must be something to show that somebody has prepared false document. And if I have used it for my gain, then I will be responsible for manufacturing that false document. And if it is of sterling quality, my lord, then definitely your lordship will look into. And if your lordship will see at page 38, my lord. We have filed a petition, my lord, in that Ms. J title suit 49, my lord. That the above noted case is fixed today under 151 CPC, that from the side of the university concerned is submitted that for just decision of the case result, starting the name of the candidates become 2-year degree examiner JB College Commerce required to be called for from the university concerned. The OP also begs to submit, that is Dibrugarh University, that for the just decision of case, original documents like original mark sheet, original percentage claim to be issued by DU required to be submitted before the competent court. So all these things are to be carried out, my lord. And this exercise was carried out in the civil suit after submission of the final report, my lord. And now your lordship will come to page 42, my lord. The prayer, my lord, I'm sorry, my lord, the prayer portion needs to be highlighted. Pray that would be pleased that to call for the certified copy, original mark sheet, OMR sheet stating the name of the candidate passing BCom examination of the 2-year degree, JB College from Dibrugarh, and to direct the petitioner to submit original pass certificate of the petitioner, original mark sheet of Rana Gosai BCom 2-year exam, and the other original they are relied upon and may pass any other order as the court may deem fit and proper. And in the meantime, the honorable court, after taking all things into account, has passed the order, my lord, at page 42. OP filed a petition number such under 151, in which OP have submitted that for the jurisdiction of injunction matter, the original result sheet of the BCom examiner of the petitioner from JB College Jorhat of the year 1980 is required to be called from Dibrugarh University. Learned counsel for the opposite party has further submitted in the petition that for the jurisdiction of the case, original document, that is original mark sheet, original pass certificate of the petitioner BCom of the year issued by the DVR are required, and hence he has prayed to call for the certified copy of the original mark sheet, OMR sheet, stating the name of the candidate regarding passing of BCom examination of the year 80 from JB College, Jorhat, and also to issue direction to the petitioner to submit the original pass certificate of the petitioner and original mark sheet of the BCom examination of the petitioner along with the other original document. Learned counsel for the OPS submitted that the aforesaid documents are very much relevant for just decision of the case and are generally preserved in strong room of the institution. That is Dibrugarh University for Saver. Hence, without an order of the court, the aforesaid document could be produced before the court on their own. No need for court's order. Dibrugarh University is asking to produce direction from the court. The court said, no, it's under your safe custody. You can easily bring it there. Could not be produced before the court on the learned counsel further pointed out that due to the above reason, they could not file any relevant documents on behalf of the university. And if the court has not allowed the same, then they have to argue only on the documents submitted by the petitioner side, which is according to the opposite party has obtained by way of fraud. Accordingly, learned counsel for the opposite party has prayed to allow the petition with a direction to the Dibrugarh University to produce the aforesaid document. On other than learned counsel for the petition vehemently objected to the petition. According to the learned counsel, the petition has already made party the concerned authority Dibrugarh University, which is represented by the Vice Chancellor, Registrar and Controller Examination Dibrugarh, and they are the custodian of the aforesaid document. Learned counsel for the petition has further pointed out that where the aforesaid authorities are custodian of the document related to the instant petition, there is no need of passing any order from the court of production for the same, as it is their own duty to produce the same at the time of hearing, and according the petitioner side has prayed to reject the aforesaid petition. I have heard the submission of the learned counsel for both sides at length, and I have gone through the case record carefully. Today is the date fixed for hearing on the injunction petition. On perusal of the written objection, it reveals that the OP has questioned regarding the genuineness of the pass certificate submitted
of the petition supported to be issued by the Dibrugarh University is the authority who has issued the mark sheet and other relevant documents of the students appearing in the examination from various colleges of Upper Assam, and hence it is necessary to go through the mark sheet issued by the Dibrugarh and the mark sheet along with the relevant documents produced by the petitioner in the instant case for jurisdiction of the case. Now the main finding, my lord. In view of the above, the petition is allowed subject to the condition that the Dibrugarh University has to produce all the relevant documents mentioned in the petition filed by the OP on or before the next day. And if the Dibrugarh University fails to do so within that period of time, hearing will take on the injunction petition. It is further made clear that if the petitioner fails to produce the aforesaid document on the next day, no any further time will be allowed to them to file the aforesaid document. It is further made clear that both the parties that no any adjournment shall be allowed to either party on the next date of the hearing. OP is to take necessary step for production of the aforesaid document as per petition number 3048 of 17 on the next date. Petitioner is to produce all the original relevant document at the time of hearing on the next date, fixing 27/11/17 for hearing on the production of the documents. So this exercise is carried out by them. So everything will be crystal clear from the outcome of the civil proceeding, my lord. And I have given a judgment to that effect that civil court judgment will be binding on the criminal courts, my lord.
Okay. Your part is over?
More or less, my lord. Just now, my lord, I have probably submitted one list of days along with that. The why the CJM order is bad in the details. In the list of days down below part, just synopsis type, my lord, and the list of books also. List of books condition. Well, in the first judgment which I am relying, my lord, of Honorable Supreme Court, my lord, Pradeep Kumar Kesharwani versus State of UP. At para 20, the Honorable Supreme Court emphasizes the following, like four steps.
Which judgment?
My lord,
Judgment?
my lord, this one, my lord.
Okay.
Pardiwala and Sandeep Supreme Court of India. Para 20, my lord. The following steps should ordinarily determine the veracity of a prayer for quashing raised by the accused by invoking the power vested in the High Court under Section 482 CRPC. Step 1. Whether the materials relied upon by the accused is sound, reasonable, and indubitable, that is, the material is of sterling and impeachable quality. So I have submitted those documents which are given to me by the college, my lord, and they have also given a response to it. So these documents are of sterling and indubitable, my lord, quality. Step 2, whether the materials relied upon by the accused would rule out the assertion contained in the charges leveled against the accused, that is, the material is sufficient to reject and overrule the factual assertion contained in the complaint, that is, the material in such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusation as false. So my allegation, my submission is that, my lord, that the allegation level me are false in view of the certificates issued by the college and of the civil suit pending. Step 3, whether the materials relied upon by the accused has not been refuted by the prosecution complaint and or the material in such that it cannot be justifiably refuted by the prosecution complainant. Step 4, whether proceeding with the trial would result in abuse of process of the court and would not serve the ends of justice. If the answer to all the steps is in the affirmative, judicial conscience of the High Court should be persuaded it to quash criminal proceeding in exercise of power vested in it under Section 82 of the CRPC. Such exercise of power, beside doing justice to the accused, would save the precious court time which would otherwise be wasted in holding such a trial, as well as proceeding arising therefrom, especially when it is clear that the same would not conclude in the conviction of the accused. See Rajiv Thapar versus, I have not given that, my lord. And the second one is, my lord, My lord, this AP Mahesh Cooperative Urban Bank Welfare forgot to brought the book today, my lord, but I have quoted, my lord. Para 22, in fact, Niharika Supra reiterate the parameters laid down in the celebrated decision of State of Haryana versus Bhajanlal.
Which paragraph you were reading?
My lord, I'm reading the second citation, my lord. Actually,
Ankur Singh.
yes, ma'am. AP Mahesh Cooperative Urban Bank Shareholder Welfare Association. My lord, the list of books, my lord. All of list of books. 2 page,
Yes.
my lord.
Yes.
So second one is that, my lord, in para 22 of this judgment, in fact, Niharika reiterates the parameter laid down in the celebrated decision of State of Haryana versus Bhajanlal. One of the cardinal principles evolved in Bhajanlal in para 102.7 reads as follows. Where a criminal proceeding is manifestly attended with malafide on where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Para 23 of the said judgment, yet Bhajanlal laid down 7 principles in para 102, the last which was extracted above. The 7 principles enacted in para 102 of Bhajanlal, a 2-member bench, are actually quoted with approval in Niharika 3-member bench. So this is the Bhajanlal, next is the Bhajanlal case, my lord, wherein 7 categories have been laid. And lastly, my lord, Honorable Supreme Court 2025, I'm relying on para 11.14. This has the approval of both the judgment, this welfare association.
Okay.
My lord, lastly, just one para to conclude it, my lord. Where the defense relies upon unimpeachable, incontrovertible evidence of sterling quality, such document of undisputed authenticity, which expresses a demonstration that continuation of criminal proceedings is unjust and oppressive, it should be quashed, my lord. So in the view of the fact, my lord, so many circumstances are there, my lord. So I respectfully plead that these persons who are the informant of this case wreaks a political grudge against me, my lord. So they have filed a false case against me wherein I have been made an accused. And on the contrary, my FIR, without making a proper investigation, my lord, has been there. And wherein in that case also, a final report ought not to have been accepted. And a further investigation is to be carried out, my lord. At least by examining those persons, my lord. And or I have already given one judgment on the earlier date, my lord. Probably it's on record, my lord. That criminal court will be civil court judgment will be binded by the criminal courts will have to bind it by them.
Yes.
Thank you. Statements of the controller of the university. Here, one is Rurat PS case number 636, where instruction submitted, and Rurat PS case number 630, 2016, where the FIR lodged by the informant, the present petitioner. In that case, my final report submitted. The main crux of the matter is regarding the whether the petitioner has passed become examination or not, my lord. Initially, my lord, one press conference in the 73 2016, and thereafter, my lord, these are all litigations, my lord, 630 2016 and 636 2016 going on, my lord. And regarding that, my lord, I already pointed out to your lordship, my lord, regarding that mark sheet. One mark sheet, police has also seen the mark sheet submitted by the present petitioner, and allegation is that that mark sheet is forged. That is the allegation against the petitioner. And thereafter, my lord, after filing of the charge sheet, some of the documents from the RTI, my lord, my petitioner has or my lord, respondent has obtained those from the controller of the Dibrugarh University, and their statement is very clear that my lord, petitioner has not, my lord, passed become examination from the record, my lord. Their statement is available in the record, my lord. And now, my lord, in that case, my lord, only my prayer before lordship, only the evidence will, my lord, decide, my lord, whether the who has whether the mark sheet submitted by the petitioner is, my lord, genuine or not, my lord. And whether the petitioner has passed become examination in the year 1981, his roll number is 858. Whether, my lord, on the basis of that mark sheet submitted by the petitioner, actually he has passed the become examination, or on the basis of the, my lord, those documents obtained through RTI from the Dibrugarh University. So regarding those matters, my lord, at the initial stage, ultimately thereafter this, by way of this criminal, after filing of this criminal division, that proceeding is taken. my lord. So my prayer before your lordship on the basis of the record, my lord, or I have trademarked, my lord. This is a matter of, my lord, evidence only that can be decided during trial, my lord. Otherwise, my lord, this.
That is in respect of this criminal petition.
Yes.
Regarding this revision petition.
Further investigation.
My lord, regarding that further investigation, my lord. Yes, well, if that petitioner agrees that both matters may, my lord, one that can be done, my lord, that, my lord, both, because there are some materials collected by the authority, just, my lord, decision of the case. If whatever investigation IO has conducted in that case, my lord, that can be tagged, my lord, and if otherwise, for to finding out the truth, my lord. If, my lord, petitioner, there is no, my lord, there is no difficulty in continuing with the.
No. We are testing the order of the
Page
CJN.
59.
Yes, my lord. Yes, that
59.
is, yes, my lord, that would have, where petitioner has said that by way of that order, my lord.
Whether that is
Final report submitted, my lord. My lord, in that.
legality, property, and correctness of the order passed by the CJN
Yes.
on the final report, on the objection filed by the petitioner.
Yes, final report submitted.
Yes, against the final report.
Yes.
Whether that withstand the legal scrutiny or not, that is the question.
Yes, my lord, otherwise, yes, in that case, my lord, I have already trademarked the record, yes, that in that case, my lord, the statement of the principal of the JB College is, I have not found. But my lord, question is whether that's the only, the statement of the JB College, my lord, otherwise evidence is documentary evidence, my lord. All those documents are there in the record. And thereafter taking the evidence of the, my lord, controller of the examination, my lord, while investigating both those cases, police has found that there are some, my lord, contradiction, the document mark sheet submitted by the petitioner, and finding all those, my lord, contradiction, IO has, my lord, there is otherwise I have rightly submitted, my lord, submitted final report by stating that yes, my lord, there is no such, my lord, material in the FIR submitted by the petitioner. However, my lord, in that case, while the controversy is going on, my lord, otherwise, my lord, if interest of justice demands that, my lord, then, my lord, then everything is required to be ultimately truth has to come, my lord. Truth has to come to that, my lord. Whether that, my lord, who is, my lord, which document.
No, Mr. Borthakur, you tell me one thing. Examination was conducted by the Dibrugarh University.
Yes, ma'am.
And they have transmitted the result sheet and the mark sheet to the
College.
JB College. And accordingly, JB College has declared the result. And it is the university authority who had stated that in the RTI reply that the person concerned has failed to pass the examination. In that view of the matter, if the principal is examined, principal of JB College is examined, and he gives a statement that the person concerned has passed in the examination, whether it will change any position or not.
Everything will be accepted.
Yes, my lord, that is because on the basis, because here the petitioner has submitted the certificate of the JB College that he has passed the examination. Yes, from that point of view, yes, statement of the principal of the JB College, whether in fact he has issued that certificate to the petitioner or not. To in that aspect, my lord, yes, statement of the principal of the JB College, my lord, is necessary.
No. Here the principal was not examined.
Not examined.
And you come to a hypothetical situation. If the principal was examined and the principal has deposed before the IO that yes, he has issued the certificate on the basis of document on the basis of data he has received from the Dibrugarh University, whether it will change any position, because the university authority who has conducted the examination has stated categorically that no, the person concerned has not passed. Whether the statement of the principal will change any position or not.
Otherwise, that will definitely not change the position. Because ultimately, the university has clarified their position. And I have trademarked the statement of the controller of the university.
Well, just one line if your lordship permits me, my lord. One line. But as it's a surface, my lord, now we are in the concluding part. Undoubtedly, my lord, there are two documents, one saying that I have passed, one saying I have not passed. But the pass, that is the certificates, my lord, all these things has not been verified by the IO in their investigation. Had they done and carried that exercise, everything would have been crystal clear, my lord. So that is one reason. Second thing, I have earlier also submitted as per my client's instruction, my lord, that he was never issued any notice as an informant to come and give his statement, my lord. Though I stated, your lordship pointed it out in the diary, it is there. But according to the client's instruction, he never appeared before the IO. And neither he has seized any documents from me also. Those documents were seized in the other case, my lord, wherein I am an accused. Wherein I have already, because my documents were already with the police in that earlier case, my lord. That is criminal petition number 74, no? 74 of 17.
Okay. Heard Mr. Z. Kamal,
21.
learned senior counsel, assisted by Mr. Learned counsel for the petitioner. In criminal petition number 107 of 2018 and no, civil revision petition number 107 of 2018 and criminal petition number 74 of 2021. And also heard Mr. Borthakur, learned additional PP for the state respondent. Argument concluded, judgment reserved.